So thank you for coming. Today I'm going to speak a little bit first about sexual orientation-based claims in general. That's generally the thing that people are the most interested in, and it gives a good kind of background into my thesis and some of the issues that I've started looking at, and then kind of where I've gone with my theoretical questions. The second part is I'll talk about my thesis, and then you'll see where the problems started occurring for me and why now I'm starting to ask some more theory-based questions and really looking at how do we recognize queer people in international law and in refugee law, and how do we talk about norms when we're dealing with pretty anti-normative concepts. I didn't start off having a queer project, but over the course of the last 3 years it became one. So some of the unfinished thoughts that you see here are right where I'm at with my thesis. So bear with me on that. So sexual orientation, of course, was not first recognized under the Refugee Convention. Pretty obviously, at the time, most of the states that were working on UN documents themselves criminalized same-sex acts. So it just wasn't a case to be made for human rights. But we know even during the Holocaust and World War II, people were being persecuted and killed because of their sexual orientation. And those histories didn't come out immediately, but they did come out over time. So it's even in the ranking system, which is probably what is most infamously known. So gay men were given the pink triangle, and lesser known women, lesbian women or queer women were given the black asocial triangle or work shy. So we know that there was persecution happening on those grounds, but states really weren't interested in recognizing rights that they themselves wanted to violate, arguably. And early on when there's one case in Canada actually really early on, where one of the tribunal decision makers actually said, well, the whole international regime of human rights is based on heterosexuality. So we're not going to recognize your claim as an asylum seeker because the foundation of international human rights is a heterosexual one. So that was only in the early 90s that someone said that. So we clearly have gone a long way in a very short time. Australia, where I'm from, the bastion of human rights, we only fully decriminalized same-sex acts in 1997, so it's 20 years ago. And yesterday, we passed same-sex marriage, which, for a lot of people isn't as exciting as it sounds because it's been a horrible process and there are so many other things that we should be dealing with. So obviously, still today, it hovers around 72, 73 countries that criminalize same-sex acts, but there's also lots of other laws on the books in many countries that are used to persecute people based on gender expression, such as laws that you're not allowed to imitate another gender, or you're not allowed to alter your appearance. Or there are many other ways that women, for example, are persecuted that aren't represented in the law, so that's really important. So the 5 original grounds for refugee status, as many of you probably will know, is political opinion, religion, nationality, race, and particular social group, which was snuck in, I think, by the Swedish through some negotiations right at the end. So for a long time, people could actually gain asylum because of their sexuality, but they did it on grounds of political opinion or perhaps on religious basis. And claims really started to be accepted and heard in countries like Germany and the Netherlands in the late 80s. So it's actually not as new a phenomena as people often say. I always hear like, oh, that's very of the now, your topic. That's very niche. It's very up and coming. Well, not really. But it was really this Canadian case in 1993 that set the standard for how the majority of cases based on sexual orientation and gender identity are recognized in most countries that receive and process cases, and of course themselves don't criminalize same-sex acts. There's a lot of countries that receive refugees who are fleeing persecution based on their sexual orientation, but they would never process it in this way because they themselves still have laws that criminalize. So for particular social group status, LaForest laid out these 3 different characteristics of the claim that would satisfy. And really this has remained largely unchanged in a lot of jurisdictions, a lot of Western ones. And even though the case wasn't about a claim that was based on sexual orientation, in his discussion of what he means by these, he said that the first category would embrace individuals on the basis of gender, linguistic background, and sexual orientation. So that was great. People immediately took that up. Australia was already accepting claims in 1992. Ironically, before we decriminalised fully, we were challenging all the way up to the UN Human Rights Committee, but we'd already started recognising claims. The UK took until 1999, so they were quite a bit slower. But then, paradoxically, their approaches have really improved quite significantly and very quickly, whereas Australia has completely stalled and maybe probably regressed. So the main thing that I want people to kind of focus on is this idea that a group can be defined by an innate and unchangeable characteristic, and that characteristic has to be shared. And this idea has really become the basis of how we talk about sexual orientation and queerness. And by queerness, when I use that term, we can, how long is a piece of string for what people think queer means? But when I talk about it, I think of someone who is not the norm in regards to their sexual orientation, who they're in relationships with, how they express their gender, or what their sexual characteristics are like. But people also, as I'll go on to talk about, take this as an identity as well. So even though it sounds paradoxical, when people talk about queer identity, they are also, there is a lot of normative build-up around what it is to be queer and how we talk about that. So Australia and the UK are quite interesting cases, and obviously being Australian, it's not that surprising that I chose Australia to be my case study. But I was really shocked when I started to look into this area like 5 years ago, how much Australia's practice varied from other comparable jurisdictions and how far behind we were compared to international best practice. And one of the main issues in my previous research has been on discretion reasoning. So this was prevalent in a lot of jurisdictions. It wasn't really in Canada. Canada, in a lot of ways in this area, it really kind of exemplifies best practice, and that's almost solely down to a woman called Nicola Violette, which people are probably well aware of her. She was over at the University of Ottawa, and she started training the IRB here from 1995 on sexuality and gender. So Canada was really ahead in how they approach these kind of claims. Australia and the UK, on the other hand, most claims up until the early and late 2000s, the decision makers would say, look, we accept that you're gay, or we accept that you're bi, or even trans, or, there's a lot of confusion around the differences between gender and sexuality. They say, sure, we accept that that is the case and that you're being persecuted on that, but you can simply just hide your sexuality and practice it in private, and you will therefore secure safety, and you don't need Refugee Convention protection. And this is really rooted in the broader historical context of recognising non-straight sexuality as a private right. I think it was only in 2014 that the UN Human Rights Committee said states don't have the right to kind of police public expressions of sexuality in the pursuit of protecting public morality. That was really a kind of an entrenched right that a state had in the international level. So it was only 3 years ago that idea that you're not allowed to push expressions of sexuality into the private realm anymore. So it's not surprising that when it came to refugee claims, that idea about non-heterosexual sexuality being something that's almost exclusively about sexual practice and a right that you had in private and not a public that you had. And certainly not thinking about it of freedoms. It was always just your right and curtailed in a specific way. So this phenomena resulted in tribunal members suggesting to applicants that they should just be discreet, they should or paradoxically they should have just anonymous sex in private places. So they're obviously only thinking about men and thinking, well, you can just go down to the park. Or they would say you can move to another city to avoid persecution, which is an issue that's really prevalent now in decision making, this idea that you can relocate. So they might find a cable that says, well, in Kabul, all the diplomats are going to this one secret gay bar, so clearly there is a space where you can be queer. Or, the age-old ones tell everyone that your partner is actually your flatmate, or just remain celibate. These are real things that tribunal members in Australia told applicants to do in order to secure their own safety. So in 2003 in Australia, and it wasn't until 2010 in the UK, discretion reasoning was overturned. And really importantly, the Justice pointed out that fundamentally, not only does it, is it incorrect, an incorrect account of sexual rights and sexuality and based in really kind of stereotypical approaches, it's actually not the job of the tribunal to dictate what someone should do when they go home. Their job is to review what has happened or what is likely to happen. It is completely beyond their purview to say, go and behave like this to be safe. So there was a lot of confusion and a real kind of tenuous position that decision makers were putting into themselves because they didn't know how to approach these claims, and so they were missing the point completely. So after discretion reasoning was dismissed, everyone thought, great, this is a huge success. Now we're going to see so many more positive claims. But actually, Jenny Milbank, who's an Australian academic who worked with Catherine Deverne, another Canadian, they did some research and showed that actually there was no significant improvement in the number of claims after discretion reasoning was dismissed. And that was because it moved to credibility issues. And in Australia, that's really important and kind of the main area that I work on now, and what has started to form some of my questions around how we think about identity, because credibility of an applicant is taken as a question of fact in Australian refugee law. So they will say, we do not believe that you are, as a matter of fact, a gay Pakistani man, and that cannot be reviewable. So you cannot appeal an instance of fact. You can only appeal a question of law. So that's where the battleground is these days. They'll say, sure, we believe that gay men are persecuted in Pakistan, but we don't believe that you're one. And the way in which they go about doing that brings out even more insidious stereotypes and offensive lines of questioning than discretion reasoning did. So it wasn't the success that we all kind of wished it was going to be. So in Australia, there was actually one case that was only finished, the decision was finished in 2015, so it's really recent. And it was actually one of the applicants who was in the case that was overturning discretion reasoning that was heard in 2002. So that same applicant had gone back and forth and back and forth and back and forth, up and down into the courts and back to the tribunal. And his credibility, after they accepted as a basis of fact earlier that he was a gay man and then had applied discretion reasoning, it went back down to the tribunal and they said, oh, actually, we don't believe you're a gay man. And one of the questions he was asked throughout his tribunal hearing, the fourth or fifth one, was whether he used lubricant with his partner when he had sex. In that, not only is that a completely, offensive and undignified question to ask someone, in that question there's a lot of presumption about what gay sex is, that you have to have had gay sex, that if you were a credible gay man you would know you had to use lubricant, and this applicant was asked, the tribunal member said, you might not want to answer this question, so he was like, no, I don't want to. And then that specific question was actually referenced in the refusal and said, because he refused to answer that question, we don't find him credible. So clearly, even in the exact same case that discretion reasoning was using, decision makers are finding any opportunity they can to discredit someone because they don't want to open up the floodgates, basically. In another jurisdiction, in the Netherlands, this case went up to the Court Justice of the EU, and it's really become the basis of what is now considered the norms around credibility assessment in most jurisdictions. And these have been adopted into UNHCR guidelines and training. So they found that under the European Convention of Human Rights, which obviously Australians cannot appeal to, or any, we're one of the first jurisdictions on the planet to write out a reference of the Refugee Convention in our Migration Act. So we no longer reference the actual Refugee Convention, and we've altered the definition. We're very inventive. But so they found that sexually explicit questions the use of stereotypical lines of questions or expectations, any use or reviewing of evidence from tests, so medical tests purporting to say that this either proves or disproves someone is gay, and junk science is included that, like junk academic work. And also the requirement that an applicant has to claim on the basis of sexual orientation in the very first instance. So you're not allowed to hold it against someone if, for example, when they first went to an immigration officer, they claimed on a different ground, because there's recognition that they're vulnerable and they might not want to tell someone in authority, let alone an official, or they might not know that they can. So these have all found, if used in decision making, to violate the right to integrity and privacy and family life. Now, obviously these don't apply in Australia, but what I wanted to find out, if these are the standards, and the UK as a case study is quite unique in and of itself because it has quite a unique legal history, particularly because it exported most of the laws that we're then referencing in asylum claims. But it has access to these decisions, and Australia does not, and really doesn't reach out to implement them on their own accord. So I wanted to know, what is it about these two cases, and what is it about these norms, about how we treat people through the process, and not simply saying, oh, well, we accept claims based on sexual orientation, when actually in the process of these claims being made, people are having their rights violated. It's not simply that they have difficult lines of questions. Arguably, we're violating people's human rights through the processes that we put them through. So that was really the crux of where my project started. So I wanted to know, well, I was fueled on this idea that if we take those sets of norms as procedural norms, so they're listed in the UNHCR guidelines as procedural issues. So if we set them out as procedural norms, how can we start to look at two different case studies and figure out why in one case they are being implemented, or even if they're not being implemented, there are attempts to implement them, because how you measure success in this area is very murky when you're dealing with norms around sexuality and gender. Whereas in another jurisdiction, there really seems to be no movement even towards attempts to implement it, and clear failures at implementation. So Betts and Orchard have started working, they published research in 2015 looking at norm implementation. And I should say I used to study under Phil Orchard, so that I also know him personally. But the idea is, if you're going to have norms around human rights and you're only talking about them in this international sphere, as we often do in international relations, what does it actually matter if we're not looking at what's happening on the ground? And if you're talking about refugee rights and you're not actually looking at how they're applying to an individual refugee, then we can say what we want. We can say, sure, these rights are, look at these big court decisions, which really only references one successful case. Look at these UNHCR guidelines, which really comes from these cases and other experts coming together and deciding on them. But are they actually being implemented? At the lowest level of decision making in these cases, which is a representative of the immigration department, who might not have any training on these issues, to tribunals that might themselves be set up to stop these cases from getting to the court, which is the case in Australia. The tribunal is really designed as a kind of gatekeeping exercise to keep people out of the courts. They don't want people to be able to claim human rights violations or procedural violations. So we need to take it right down and look at it. And the second quote is from a report, which was the first ever report published internationally on LGBTI asylum seekers. And it really points out this idea that just because a country appears to be liberal and just because they appear to have LGBTI rights and they appear progressive does not ever mean that that's translated into an asylum context. And Australia is almost astonishing in this area. Notwithstanding same-sex marriage that we got yesterday, Australia has some of the most progressive anti-discrimination legislations for LGBTI people on the planet. You know, we're not Malta or South Africa, but we have pretty good anti-discrimination legislation. But if you're an asylum seeker, in some instances, we'll send you to Nauru or Papua New Guinea, which both until this year criminalise same-sex acts. So arguably, if we know that someone is gay or trans and we send them there, which we do and we have, we are actively persecuting that person. So sure, we can say we have this great LGBTI rights, but if you don't have citizenship in Australia, you don't have any access to those. And one of the lawyers who I actually spoke to said that when she's dealing with LGBTI clients, it's as if they have to give up all of the rights that they would normally have until they get asylum, and then they can make these claims. Because they're dissuaded from doing it, they're fearful of doing it, it'll bog down their claim. You know, the Australian government is quite vindictive in trying to stop people from doing that. So on the constructivist theory side, you know, historically, when we talk about norms, which are these kind of accepted, theoretically speaking, they're these, you know, accepted, expected standards of behaviour, it started off really talking, as classic IR always has done, at the state level. So this idea that a norm at the international level would, you know, be taken up by a few states, and then it would reach this tipping point, and then all of a sudden it would just be taken for granted, and all states would accept that as a norm. But quite a few scholars started looking at, well, what does that actually mean when you're implementing it at a regional level? Is there a particular cultural context? And now people are looking at, well, theorizing, well, institutionalization is one process, but implementation is another. And often implementation of a norm is attempted in a domestic context before it goes up to the international. So you're missing this whole process that's happening. And at the same time, even if a norm does make it up to an institutional international level, when it comes back down to the domestic level again, it has to, you know, work in a different cultural context. It might be entirely, you know, differently interpreted, and it has to compromise in really complex ways within legal systems, political systems, cultural systems. You know, what one person's view of sexual orientation in one context is going to look very different than in another. And then you're also dealing with someone who comes from another cultural context entirely. So simply to say you can't ask stereotypical questions almost means nothing when you're dealing with stereotypes about sexual orientation within your own context and also within other people's cultural contexts. But alas, that's what I'm trying to do, looking at how these norms are being implemented. But you can see that I've started to kind of find real issues with our concepts of norms. So if there are norms around sexual orientation and norms around identity, and the real push in this area of law has been, if you're not going to ask sexually explicit questions, then you should be trying to elucidate someone's identity. And that's the better way to do it. But that becomes quite problematic, because how do you figure out what is an innate, shared, universalifiable identity, say, of a gay man, without really doing harm to the lived experience of real people? And people are not going to be able to meet those expectations. So, I have some of my own normative goals for this project. The first one of them is the idea, at least in the Australian context, was, well, if you can find these different areas at the domestic level where norms are being implemented and are being changed, then you can target these sites. So I should rewind a bit. So Alexander Betts and Orchard, in their implementation theory, they identify 3 different domestic structures that they theorize influence a norm being implemented. The first is ideational, which is so like cultural, social, our understandings of sexuality, our understanding of what a good refugee is. Then there's institutional, which is like, what is it about the makeup of bureaucratic processes, like the tribunals and court systems? What is it about the processes in those countries or in a specific context that makes a norm more likely to be implemented or not? And then material, which I kind of translate into political will. It's like, where's the money, basically? Does this state have the money? They almost always do have the money, but do they make the political choices to spend money to either improve processes to try to make, attempts to implement the norm better? Or are they actively investing money in ways that block off? So, for example, Australia is spending billions of dollars sending people to countries where they don't have access to these rights. It's a really good example of a specific domestic material influence stopping a norm being implemented. It's a very brute example. So my idea is, if we can figure out what specifically is it about Australia that can demonstrate why these norms aren't being implemented, then those are sites that we can push and try to change. But at the same time, I don't want to kind of unnecessarily advocate that what is in these procedural norms is necessarily the right thing. So a lot of the guidance that's been developed around these procedural norms has been along the lines of, what you should be doing in these claims is you should be asking people about their childhood. Then, they should have felt different. And then in their teenage years, did they struggle with it? Did they feel ashamed? Were they ashamed of it? And then can they demonstrate harm? And now do they have this really singular, static, immutable identity that won't change? And are they going to pride in the country that they're claiming asylum? I say that as a joke, but that's exactly what's expected. And within that is a set of norms that have been established around sexual orientation that simply do not meet the lived reality of people seeking asylum. Some of the work that I've done so far is looking at that just specifically for women. The idea that, Iranian woman, mother of 3, is going to go to Pride or would be going out to gay bars, and that's how they could demonstrate that they're part of the queer community, is ridiculous, but that really is what is expected. Or, for example, the idea that you've always known you were gay, so why would you marry a man and why would you have children? And if you have done that, why aren't you demonstrating how horrible and terrible that was? Or why are you dating a man again? We don't find you credible, which is a really regular experience for a lot of queer women. So this was at the point in my project where existential crisis happened, and also because in my outside life I was giving training on how to best assist LGBTI applicants. So I started wondering, am I contributing to the problem? So I stopped doing the training. And I was really starting to wonder, when we say, okay, this norm is being successfully implementing, are you then becoming part of the process that's saying this is what the norm is and this is how an applicant should be assessed? So then I was doing a constructivist project, and a lot of people were like, you can't queer constructivism, one is about, well, I'll go to the next slide. One is clearly about something that's completely anti-normative, and the entire point is about measuring and looking at norms and how they're moving and how they're being accepted and looking at whether they're successful or not. And the other one is about rejecting norms entirely. And I was like, that's a fair criticism. But actually there's a lot of crossover between queer theory and constructivism, which I'll get to in a second. But what I really started to think about is, of my own brainchild, I came up with the terms core and peripheral norms. So if you're dealing with these procedural norms, which are looking at how we can protect people through the process, if we think of them as peripheral norms around the asylum context, there's the core norm of how we actually recognize sexual orientation within the system, and that can't be ignored. So in my project, I started off just saying, I'm taking sexual orientation claims and no other queer claims, not gender identity. This is how it's recognized in the law. This is how they talk about it. I'm just going to measure it. I don't want to deal with that. But all of the issues that started coming up with how these, stereotypical lines of questioning or sexually explicit lines of questioning, they're all connected to the kind of core fundamental constructions of sexuality that are underpinned in particular social group status, that are also connected to how sexuality has been recognized in international law, so that it was always a private right up until literally this decade, and then how it's been recognized in the domestic context, which for Australia and the UK, it mirrors the international pretty neatly. So I thought, crap, here it goes. Like, now I'm actually going to have to go back and think about, if I say something is successfully implemented, am I endorsing that as a practice? And I couldn't do that anymore. So one of the main issues that I started looking at is, well, how do you recognize queer people within human rights? How do you establish norms around respecting queer people without doing kind of injustice or, you know, essentially creating prototypes of what like a good queer person in the international is? And it's very difficult. But I really like here Anthony Langwhite. You know, there's a clear paradox when you're dealing with queer people and international law. Law and international policy is all around setting these kind of global shared understandings and standards, setting these kind of baselines for how we can recognize people's rights. But if you are then questioning, you know, the idea that anyone would have to represent themselves in a singular way to access that, you're in a sense critiquing a lot of the successes that have been made in this space. So identity, though, you know, it's both dealt with in queer theory. There's a lot of criticisms over how we construct identity. But at the same time, there's actually, you know, identity has been the basis for constructivism for a very long time. And Felix Behrenscoder, who he's been working on identity and constructivism for quite a while. He pretty much started arguing that no one really knew what they were talking about within constructivism when they're talking about identity, whether that's at the state level or whether that's at the individual level. And yeah, I still don't know what I'm talking about, obviously, but I find him pretty convincing, because he basically said, whenever we talk about identity, people generally just say, oh, it's the culture. You know, oh, that state's culture is what causes them to do that. But again, like, what's culture? So, you know, while identity is at the core of constructivism, you know, some have said, you know, it's completely murky and difficult to fathom. Another scholar was saying, you know, it tends to mean too much when you're using it in a very strong sense, or too little when you're using it in a weak sense. It's not actually very practical if you're trying to figure out how someone's identity or how a state's identity is constructed, and then trying to predict how they're going to behave. We don't really know what it is. So I hope people understand that movie reference. It's a classic. So what I started looking for is like, okay, where are the overlaps in these two areas? And actually what I started finding was the same conversations are being had in queer approaches to IR that are happening in constructivism around identity. They just don't talk to each other. And that's, more broadly speaking, queer IR has only really just been accepted now. I think ISA next year is going to be like the queerest ISA on the planet. And it's in San Francisco. So it's going to be great. But, you know, it's really like only in the last couple of years that people like Cynthia Weber have been able to convince the mainstream that queerness as like a deconstructive critique of IR is valuable. You know, it's not there to build theories, it's there to just critique everyone, which is a very queer thing to do. But in both of these areas, ideas around how identity is constructed in the international are being had. So Behrenscoder starts talking about the pursuit of ontological security, and he describes these anxiety controlling mechanisms that states or actors go through, or we put states and actors through, to try to seek some sense of identity. You know, how do you explain daytime? How do you explain what's going on in the US? You know, like, what are the processes? So he basically lists out four, I won't go into them in great detail, but four mechanisms that we put states through or actors through to seek ontological security. The first is quantification, so we like to categorize and put numbers and statistics to start understanding the qualities of that state. We look for routine practices, so you try to find pattern behaviors, things that are predictable about a state. We look for narratives, and narrative is the big thing that's happening in the asylum context. So we want things to make sense, and Enlightenment principles forever and ever. We want things to be developmental. So it should always be moving in one direction, it should make sense, and it should be incremental. That, again, is how we expect an asylum seeker story to be. This coherent narrative, it's all going in one direction, and it's all improving, and you're going to grant me the final freedom. And they all operate in an international system that's anarchic, or the classic system. So these processes are what makes everything make sense and how we can think about things. And it is almost a perfect explanation for what we put refugees through, to make sense of their histories, make sense of their identities, and figure out whether we want to give them refugee status or not. Another Canadians really, they run the show in this space. But Audrey Macklin, she's written about how tribunal members and decision makers, they operate with complete radical uncertainty. They have to understand so many different parts of an applicant's claim, the context, the law, whether or not they believe that person about their identity or the basis that they're making the claim. But then also they have to really decide whether they send someone back to harm or not. It's a very stressful situation. I spend a lot of time criticizing decision makers, but the administrative process of granting asylum is actually one of the most complicated and important processes that a state does, but it's really forgotten about until it gets into the courts. So people who are kind of familiar with queer theory will think, well, those processes and those ways of trying to figure out someone's ontological security or identity are processes that have been happening forever and ever in feminist thought and in queer thought. So Cynthia Weber, in her new book on queering IR, she starts to try to develop a methodology, and she points to Donna Haraway's idea of figurations. And it's this idea that figurations are created images that people inhabit that are supposed to represent the real world in some way, and they're performative. So through the performance of an identity, it becomes thus. But the idea is that it's never supposed to be static or representative of someone else, that, the real push at the moment is to think of identity as, rather than and or, the binary, so good and bad, gay or straight, man or woman, that you can be either or, which is Roland Barthes' idea. So this idea that you can be more than one thing at the same time, and it can be multifaceted and fluid and move back and forth, and it can, really make no sense. And taking that into IR in general is kind of, a great way of thinking about how a state can be more than one thing. So again, in a really rudimentary way, Australia can be great for LGBTI rights, but at the same time, it can be persecuting people on LGBTI rights. It can be both of those things. And measuring good and bad states for LGBTI rights makes no sense unless you're looking at how it treats all different levels and classes and citizenship status of people. But also, I don't actually think this goes far enough in this context. I think that approaches in IR are still a bit too positivist, because there needs to be space for, it's a bit, too much, but the and, the either or not. Why does someone have to be something? Why does your identity have to be articulated? Why can you simply not be the norm? Why does that have to be replaced by an expression of identity? And then why is the only way you can access your right through some form of expressing an identity? And this is a real debate that's going on within LGBTI human rights literature and approaches to IR, and then the difference between academia and practice. When I bring up these ideas, when I'm in my advocacy circles, they don't go well. Particularly because you've got to recognize different cultural contexts are at different levels with recognizing sexuality. So when I'm at a conference saying, can't we just give up labels? There'll be, one of my colleagues, Steve from South Africa, would be sit down. We need to be recognized as, say, lesbian women before we can, break the gender binary kind of thing. So I recognize this is a very theoretical discussion and not actually practical, and it might not actually work in the asylum context. But I think it's important to think about it, and it's important for constructivism, because if we're going to be looking at norms, and we're going to be looking at norms attached to identity, and we want to be furthering the discussion about how we protect queer people, you really need to be thinking about, are identity-based human rights actually meeting the needs of the people that we think we're creating them for? So I might wrap up a little bit now, because I know I'm running over time. But the idea that I really want to start thinking about is, how can we start recognizing people's rights? And for example, in the asylum context, how can you recognize someone's persecution without forcing them to create this narrative around identity that, while it might work for them in their instance, could potentially further marginalize other people? So are we developing this kind of norms around sexual orientation that in the end will make it harder and harder to gain asylum? The one example of that I would give is, feminists are always there first. And feminist approaches to refugee law, they really worked hard on getting claims processed and getting them approved on the idea that a woman can be persecuted because she doesn't live up to the social expectations of her gender. So if a woman refusing to be married, she's being persecuted because she's not behaving in a typical gendered way that she should, and therefore she should be granted asylum. But we're not at all having those kind of conversations in the sexual orientation or queer space. Instead, we're pushing for identity. So I'm wondering how we can start having those conversations and looking at non-identity based approaches to law in this space, and whether it can potentially push constructivist norm theory towards being more useful for queer people. But I don't know. So that's where I'm at. So I encourage any